My name is Ponniya. I'm delighted to speak at this virtual summit. And I want to thank all of you for attending this session and for making the time to attend this session. Now, my session is going to be about how we protect the business from litigation angst over contractual issues. Now, litigation angst is a subject I'm all too familiar with, given that I've been doing disputes work for more than 20 years and working with clients from across the Asia-Pacific region. Now, I'm going to be speaking for 10 minutes before I pass on to my colleague, Anne, who will speak about supply chain-related issues. Now, in the 10 minutes that I have, I'm going to be touching on a few issues. And there are two key words that I want you to walk away with. The first is clarity. Clarity over performance that is required under the contract, clarity over what constitutes non-performance under the contract, and clarity as to what would excuse non-performance under the contract. The second keyword is certainty, and it's certainty of recourse, right? What are the consequences that would follow when there is a failure to perform the contract? So I'll start off with clarity. And like I said, it's clarity over performance that is required under the contract and what constitutes non-performance, right? And, my colleague Anne will touch on supply chain related issues, but for example, would a failure to procure materials from a particular source, would that constitute a breach of contract? Would that constitute a failure to perform? The exclusivity of the source, is that a requirement under the contract? Right? That's something that you need to be mindful of at the beginning when you are looking to sign the contract. These days, it's very common to see the language of material breach being used in a contract. But what constitutes a material breach? Now, generally, it would be a breach that deprives you of substantially the benefit of the contract. But that's open to interpretation, and sometimes you get disputes over that. Would you say a breach, a technical breach that goes unremedied for a period of time, would that be a material breach? Now, again, that's something you can spell out in the contract to make sure that there is no dispute as to what constitutes a material breach. In some contracts, it is quite clear as to what constitutes a material breach. There are provisions that make it quite clear as to when there is a material breach in place, and from that, certain consequences will follow. Insolvency is an issue that we are dealing with these days. And would insolvency in itself be a breach of the contract? If a party were to file for insolvency protection, would that be a breach of the contract? Now, that's something you need to think about. And it's something that will depend on the insolvency legislation of the country where the counterparty comes from. And that varies from one country to the next. So again, these are issues that you need to consider right at the outset, right, as to whether or not there is going to be a breach if a certain party behaves in a certain way. What constitutes performance and what constitutes non-performance? You also need to think about what would excuse non-performance. And again, I think all of you in this particular climate where, in the COVID-19 pandemic, you would be familiar with the language of force majeure, right? And force majeure essentially is any event that is beyond the control of the parties that prevents performance. Now, that's defining force majeure in the broadest possible terms. And this varies from one contract to the next, how you define force majeure, right? An appropriately drafted force majeure clause could excuse a party from having to perform the contract, right? And you need to see how wide it is and how specific it is in certain cases. Would it extend to a pandemic, right? And these are some of the issues we are working with our clients on and trying to invoke force majeure. The other thing that you see in force majeure clauses, which are becoming increasingly sophisticated, is that there are preconditions, right? There is a requirement, for instance, for advance notice to be given, a requirement for mitigatory steps to be taken to reduce the effects of that particular event. And you need clarity as to how far you need to go, right? So assuming you do not give the notice in time, does that preclude you from invoking force majeure? Assuming you don't take the necessary steps to mitigate the damage, again, does that preclude you from invoking force majeure? And all of these needs to be spelled out in the contract. Another variation of force majeure, well, it's a different term altogether, but you could put it in the same family, is material adverse change clauses, right? In some cases, particularly in the mergers and acquisition context, where you're looking to buy over a particular target. Now, if there is a material adverse change in circumstances, you could basically not proceed to close the deal. You could back away from the deal, or you could renegotiate. Again, what would constitute a material adverse change? And this is sometimes open to interpretation. Do you need to put in financial parameters? Do you need to consider commercial issues? Now, I appreciate that sometimes it's very difficult to predict and foresee and anticipate issues that would get in the way of performance, which is why you have the language of material breach and material adverse change, right? But where you are able to predict, where you are able to anticipate, then it's best to set these out upfront in the contract, right? There's also a balance, right? Sometimes you might be in danger of disqualifying yourself by being too precise. And what is really needed is an assessment right up front of what would constitute performance, what would constitute non-performance, right? And mitigation and an assessment of the risks involved and how you would go about mitigating those risks. So these are some of the things you would do right up front. Now I move on to the other keyword, which is certainty, right? And this is certainty of recourse. Now, when there is non-performance, what are your options, right? You could, for instance, suspend the contract and look for other parties to work with. You could terminate the contract, bring the relationship to an end. You could renegotiate. You could initiate formal legal proceedings, or you could consider extra contractual options like insurance, for instance, right? Now, all of these options involve a certain process, and you need to think about how you would initiate that process and how you would follow through step by step, right? For instance, when you're looking at suspension and termination, you would need to make sure that the notices are issued in time and they're appropriately worded. If you're looking to initiate legal proceedings, you would need to think about the steps you need to take to initiate legal proceedings. In some clauses, there are mandatory mediation. You know, I've seen clauses, for instance, arbitration clauses, where, you know, the seat of the arbitration is not specified. So it goes back to the first keyword, which is clarity, right? You need to make sure that there's clarity as to the steps that need to be taken, and you need to be able to try and follow through on those steps, right? So otherwise, you would get into a dispute over initiating dispute proceedings as opposed to a dispute over the underlying contractual obligations, right? And trust me, these things cause a lot of litigation angst, right? To be not able to initiate dispute proceedings to resolve the underlying contractual dispute, that is a source of much frustration, right? And even with insurance, for instance, right? There are insurance contracts that would set a time bar, right? A time bar of a year, for instance, but after the event has arisen. So if you feel that you are entitled to insurance coverage, then you have to make sure that you give notice in due course within the time frame spelled out in the contract, right? Otherwise, you are disqualifying yourself from insurance coverage. And trust me, insurance coverage saves you a lot of litigation angst, right? There is security of coverage. So you need to understand what is the process set out in the contract following a failure to perform the contract, and you need to make sure you follow through on that process step by step, which takes me to the point I made earlier. I think it's important that right up front, you do a risk assessment of your contract. What is it that you are required to do? What is it the other party is required to do? What would excuse you from doing what you're required to do? And what are the consequences if the other party fails to do what is undertaken to do? Once you've done that, you can set out the process, and you have to make sure that you follow through on that process every step of the way. So that's all I had to say on this particular topic. Let me pass on to my colleague, Anne. Thank you.
Thanks, Kumar. Hi, everyone. My name's Anne Petterd. So what I'd like to do is build on some of the excellent points made by Kumar and look a bit more at the strategic issues when we're doing our supply chain planning. And I thought I'd focus on two areas. So the first topic I'd look at is strategic issues that you might want to consider in negotiating individual supply contracts. So some of the sorts of things that Kumar's been talking about and some additional considerations. And then secondly, looking at the bigger picture, I thought I'd share some thoughts on navigating, the multiple supply chain disruption issues that we're starting to see and will continue to see going forward. So firstly, looking at supply chain issues for individual contracts, like Kumar, I've picked two keywords. So if I could pick two keywords in having as a guide to reviewing a supply chain contract, whether it's for procurement, transport, manufacturing, those two words would be context at the moment and flexibility. So to unpack context a bit more, when entering a supply chain contract, a party needs to think about at the moment the terms it really needs, as opposed to the nice to haves for the arrangement. Now, practicality is key in balancing cost with must have requirements. So as one example, this year we've seen producers of goods needing to enter new short-term arrangements to supply goods to new customers. New arrangements are being entered into. And perhaps there's not time to vet the new customer or vet the new supplier according to usual due diligence processes, including things like credit checks. And so just because the parties do not know each other really well, coupled with general liquidity concerns about at the moment, there can be a bit of distrust with when will payment be made. So one practical solution we've seen a lot lately is a rise in escrow payment arrangements, with a trusted third party holding the funds until the goods are delivered. So, parties are needing to sort of, look at the context and decide what different arrangements they might need. Then coming on to flexibility, the need, particularly at the moment, for contractual flexibility is a really important issue. So, given business uncertainty, many companies may well be thinking they need flexibility, wherever they can in supply arrangements. But flexibility can often come with a price. So things like rights to cancel orders or change volumes in response to changes in demand, they might be an important contract clause that businesses want to include in this year's contracts. For example, a customer might want to be able to cancel or reduce an order, maybe subject to paying a cancellation fee or maybe paying a higher price. But, is that flexibility needed in every contract? So again, context. Businesses need to be careful about, issuing edicts replying, rights to cancel, at any time in all contract, because they'll be paying for that and they might not need it. So flexibility has also been an increased issue of focus for suppliers at the moment. So suppliers have faced disruptions to inputs. So that's resulted in some suppliers seeking greater flexibility on delivery times. They might want longer delivery times and they might have greater reluctance to accept things like liquidated damages for delay. Now, Kumar touched on force majeure clauses, and while they can be used, maybe the supplier might prefer, more the comfort of having a longer period to deliver under the contract, as opposed to needing to rely on interpretation of a force majeure clause. So parties are also quite reluctant to lock themselves into supply chain arrangements at the moment. Customers aren't really looking to agree exclusivity arrangements at the moment, wanting to keep their options open in case they need to get alternate supplies elsewhere fast. So a final area where suppliers have sought flexibility in contracts is being able to substitute inputs for suppliers. Maybe they've got some short-term sourcing issues. Now, an obvious issue for customers here is whether the substituted product will still meet the specification and quality standards and other standards. So, in thinking about allowing flexibility on the inputs into supplies, really important to assess, well, what must have and what things can be substitutable. Where might there be a little bit more room to negotiate? And the answers to that are going to differ from contract to contract. What are my key contracts where I still need those short delivery times and things baked into stone as much as I can, and where can I be a bit more flexible? So the other topic I wanted to touch upon was, navigating supply chain disruption issues going forwards. So, what we're seeing now is supply chain disruption, impacting business decisions like never before. We're seeing a growing amount of supply chain disruption, and there are multiple causes. And that means that there's also multiple, at times, conflicting issues that we're needing to navigate in trying to work through that supply chain disruption. So, for example, there might be immense pressure to keep supply chain costs down, such as finding low-cost production. At the same time, businesses are needing to factor in geopolitical issues, carefully watching, for example, trade wars, or maybe increased pressure by government to onshore production of certain items. So, a definite trend we're seeing as part of this is that supply chain decisions are very much being elevated to board level like never before, part of the strategic direction of the business and, frankly, business survival. So supply chain discussions are no longer a logistics back office siloed issue. In large part, I think this is part of the immense complexity of the issues around supply chain disruption that businesses are needing to take into account when they're trying to navigate what to do. So businesses also need to factor in supply chain issues, that are going to be important to, the users of their products. Issues like sustainability and modern slavery, workforce issues really coming to the fore, particularly with the informed consumer. And lots of people listening would have familiarity, particularly for their own organisations, with things like sourcing codes of conduct and reporting requirements that might deal with some of these sustainability and modern slavery issues. So businesses now also need to be looking into the future about how they might, if they can, shock-proof their supply chains, and also looking forward digital transformation projects, use of data, robotics, things like that. So many things going on with managing supply chain. And of course, we do need to recognise the current situation, and we still have many businesses, still navigating COVID-19 related supply chain issues, fluctuating demand, transportation delays, and concerns, for example, about how their supply chains will even be funded. So, what does that mean for in-house counsel? In practical terms, in-house counsel and those responsible for risk management and strategic planning will probably find themselves needing to be across a range of tax, trade regulation, employment, government incentives or restrictions, foreign investment, environmental, I could go on, but a range of issues in order to give guidance to the business about the critical issues that the business is trying to navigate with supply chain disruption. Now, you'd appreciate that there's a fair amount of complexity in those issues, and it's a hard ask to expect in-house counsel, who might mainly deal with contracts, should become an expert in trade wars overnight and tariffs. But my experience is that businesses and their boards, often do look to their in-house counsels to assist to triage and project manage the sorts of supply chain issues that businesses are facing at the moment. Particularly when the issues involve multiple areas of the business. In-house counsel is often really well placed to have a good understanding of most business functions. So, while you might not be able to get across all of these issues, my tip in seeking to understand things is to, focus on the business impact and the business decisions that might need to be made. So, for example, do the trade war issues, perhaps bringing higher tariffs, does that mean that manufacturing might need to be moved, or supply markets, change, the customer base change? And so understanding the business decisions that might need to be made, I think their in-house counsel can add a real lot of value to the business in trying to navigate these supply chain disruption issues. So that ends my part of our session. So thank you very much for joining myself and Kumar.